Yes.
Yes, my lords, my lady, we have sought over the lunch adjournment to identify some other passages in the judgment which we say go to both purpose and the particular position of CS8, findings of the judge which are not challengeable and challenged. I'll just give them to you so they're on the transcript.
Hang on
rather
a
than
second.
going
I
through
seem
them.
to have a glitch. Leave it, okay. We're leaping into action here.
Are we good to go?
Quite. Got something on the internet that asks me whether I want to fix my USB-C problems.
Right. I wouldn't
I didn't
answer
know
that.
I had. Hang on. Yes, far away.
Good. So I'm just going to read these into the transcript. The third sentence of paragraph 170, the final sentence of paragraph 186, the first two sentences of paragraph 174, paragraph 175, the second sentence of paragraph 178, and paragraph 182. We have looked at some of these, but those are some further references. But we do say that it's the entirety of the judgment, obviously, that must be looked at. And it's somewhat difficult to pick out little particular sentences to say that there's a finding that's insuperable. Our position is that the judgment as a whole and the findings she made within it and the conclusions within it are insuperable. Now, with that in mind, we turn to the final element, the in good faith elements, dealt with in the appellant skeleton at paragraphs 70 and 71. And what that means in legal theory is set out, or at least proposed, in Macpherson and Key, Authorities Bundle 1088. And it makes the obvious point that good faith connotes honesty and propriety. That's obviously correct. But it makes the further point that in the insolvency field, the expression has been interpreted to be concerned with ensuring that a person does not intend to benefit at the expense of other creditors or collude with a debtor in prejudicing the creditors. But that, of course, is really simply a specific aspect of the general duty of honesty and propriety. So it's a subjective standard, obviously, not a negligence standard. Now, the judge heard both Mr. Mazzagatti and Mr. Dixit-Dominus cross-examined, and she held that they had acted in good faith throughout, and of course that is not challenged. More to the point, perhaps, the appellants have disclaimed any attempt to appeal either the 423 claims or the conspiracy claims, because they accept that they can't appeal those in light of the factual findings made by the judge. Now, it's quite clear that from the judgment that the judge's findings in relation to, I'll call the impropriety claims, her reasoning was that having made the findings she had made on the 238, those claims simply could not get off the ground. So we find it hard to see how they can accept, the appellants can accept, that they can't argue good faith in relation to, or proper purpose in relation to those claims, but nonetheless maintain a challenge on good faith in relation to the 238. The way they seek to do that is to suggest that there's some principles of law which show that good faith can't have been found in this case. And the first principle of law is said to be the White Star decision, where it's said that from that case it can be seen that if a party doesn't conduct due diligence on his counterparty, entering into that transaction is a failure of good faith. White Star doesn't decide that. Again, I'm not going to take you to the case because I don't think it was referred to, I don't think you were taken to it in any detail first time round, but the headline point in
Judge Hodge's case, isn't it?
It's
the case of Judge Hodge.
That's correct, yes.
Yes.
the point about White Star, when you come to look at it, is the question was whether a third party, having received company assets in breach of the company's duty, could nonetheless hold on to them on the basis that it was equity's darling. In other words, you'd received them in good faith and for good consideration. And there it was held on the facts that the recipient had reasons to believe that, that the assets were not assets to which that the company was entitled to alienate. And having those reasons and not having asked questions, they could not claim to be equity's darling. That doesn't really help you very much on whether there is good faith in this case. In this case, the judge held that Mr. Mazzagatti had no reason to doubt that Fujairah was an undertaking with the substantial support of the state of Fujairah, I should say FIOGC, guarantee would be acceptable, and that the transaction would have the result that CS8 could carry on the operations and pay its dues. So the first argument under this head derived from White Star, that there's a rule of law that a failure to carry out due diligence always amounts to bad faith, fails, and the judge's conclusion on this argument, which you see at paragraph 257C of the judgment, fails. Now, the second point made in the skeleton argument, it said that Mr. Mazzagatti failed to act in good faith because he didn't know or he didn't give separate consideration to the position of CS8 when he proceeded with the sale transaction. And two cases are cited in relation to that, Charterbridge Corporation and Fong and Yik. But neither of those cases are concerned with what amounts to an absence of good faith in this context, or holds that a failure in a group situation to separately consider the interests of a company amounts to an absence of good faith. Those cases are concerned with how a director who's charged with a breach of fiduciary duty can rebut that contention. In those cases, the proposition is that where the director has not distinctly considered the interests of one company, of which he is a director, as against the interests of the group, he can't claim to have acted in accordance with his fiduciary obligations unless he can rely on an objective standard. That is to say, he can say that a reasonable director in his position would have embarked upon the course of conduct which is alleged to have been embarked upon in breach of fiduciary duty. So it's concerned with directors' obligations to their companies, not with the question of good faith under section 238. And these cases, we say, are a bit of a distraction from the main question here, which is whether Mr. Mazzagatti acted in good faith for the purposes of CS8's business. And of course the judge held that he had done. She made a comment about this sort of argument in the judgment at paragraph 255. Perhaps I can just take you there briefly. Page 195 of the core bundle. She makes the point that good faith under 2385 is not necessarily the same question as to whether Mr. Mazzagatti and Mr. Dixit Dominus were in breach of fiduciary duty in failing to act in the best interest of the company, although plainly there's an overlap. But as I said a moment ago, what you get from those cases, those two cases, is that if the director fails to consider the interests of a company distinctly from the interests of the group, he will not be said to be acting otherwise than honestly and in good faith, provided that an intelligent and honest person in the position of the director could, in the whole of the existing circumstances, have reasonably believed that the transaction was for the benefit of the company. That's the proposition that comes out of both of those cases. So it follows that this argument, even if it were correct on the facts, doesn't assist the appellants because it collapses into the same test that has been on this hypothesis applied and passed under section 2385B. The point is made by reference to some passages in the transcript. It suggested that Mr. Mazzagatti and Mr. Dixit-Dominus did not separately consider the interests of CS8 distinct from the interests of the group. The problem with those passages, and I think I will leave the court to look at them in their own, as they consider their decision, but you'll see when you look at them, the problem is that it wasn't always put squarely to Mr. Mazzagatti or Mr. Dixit-Dominus. You decided to do this because you are acting in the interests of Rockrose Group against the interests of CS8. And when you look at the passages, it's clear that Mr. Mazzagatti and Mr. Dixit-Dominus are not really following that point as lying behind the question that you preferred Rockrose Group to the prejudice of CS8, and therefore it's not very surprising when you say to a witness, well, you were concerned about the interests of Rockrose Group, that the witness says, well, yes, I was. The real point is, were you concerned with those interests distinct from the interests of the company? And those passages do not make good the proposition that they preferred Rockrose Group as against CS8. We have referred to, in our skeleton argument, paragraph 46 and at footnote 90. You'll see this at page 63 of the call bundle. Perhaps I can invite you to look quickly at that. Some references to where Mr. Mazzagatti, in particular, gave evidence, both in his written statement and orally, that he did have regard to the interests of CS8 and why he had regard to the interests of CS8. In particular to the oral answer on day 5, I don't see how we could prejudice CS8's creditors because we had a government company that was ready to put a parent company guarantee and guarantee all JV partner was the best interest of CS8, was the best interest of CS8 for a company that was kind of related to the government as well, so finally we could find an agreement to work together in a peaceful environment. So the issue of what Mr. Mazzagatti and Mr. Dixit-Dominus considered when executing the dividend so as to extinguish the receivable is much more nuanced than appears from the isolated extracts in the transcript which the appellants rely on, and it's dealt with fully by the judge at paragraphs 255 to 258 of her judgment. Again, findings not challenged and supported by the evidence. The third and final point made on good faith under this, by the appellants is that Mr. Mazzagatti cannot have been acting in good faith because he didn't know how much the receivable was worth when he agreed that it should be extinguished. And so that was bad faith. Well, that's simply wrong on the facts. And we deal with that at paragraph 48 of our skeleton argument. The evidence was that Mr. Mazzagatti did know the approximate magnitude of the receivable when he decided it should be cleared before sale. That's to say it was greater than $60 million. And of course he knew the precise amount in the face of the declaration of the dividend which he signed. But in any event, that point can't constitute evidence from which it could be said that the only conclusion open to the judge was that Mr. Mazzagatti had acted in bad faith. And apart from the White Star point, the point about all of those points is that they are saying that because of those matters, the only conclusion the judge could have reached was that Mr. Mazzagatti was acting in bad faith, and individually or together, they simply don't make good that proposition. So, my Lord, on remedies, I think we're all agreed that if we get to it, the remedies, the question of remedies, will have to be remitted to the judge for further consideration and argument. So I don't think I need to say anything more about that. Mr. Hubbard may say some things about that by reference to the pension point, but there are other issues, both causation and the position of the claimants in this case, which would bear on that, which the judge didn't have to deal with. My Lords, the final point I would leave you with is that the judge did not make any findings, and in fact positively disclaimed any suggestion that Mr. Mazzagatti, Mr. Dixit Dominus, or indeed Rockrose had acted improperly in relation to this transaction. And whatever decision is made on the points of this appeal, those findings, the absence of impropriety, cannot be reopened. Various comments have been made in the course of exchanges with the bench over the last 2 days, perhaps suggesting some scepticism. The phrase used today was, I think, raided the till. Now,
I don't think anybody said raiding tills.
Well,
if you look
in
at
any
the
event,
transcript, they remember that.
well, in any event, of course, between bar and bench, we're used to those sort of exchanges, but it does cause concern with clients, and it's very important that it is understood that there is no suggestion of impropriety on the part of my clients in relation to these matters. Unless there's anything else.
No, thank you.
Thank you.
Mr. Howard.
My lords and lady, could you give us a couple of minutes to effect the switchover, please?
Well,
I'm not sure a
30
couple of
seconds.
minutes is necessary. I can certainly switch over.
Now, I'm going to address you on the appellant's legal objections to the judge's findings in relation to the premium liability. I'm also going to address you on the correct procedural route in terms of the appellant's factual challenges to the judge's conclusions. In relation to the first point, I think I can be reasonably brief and go through it quite quickly. In relation to the second point, so the factual challenge, I'm going to try to dissuade you from the path which I think at least my Lord, the Master of the Rolls, has taken a couple of tentative steps down and try to persuade you there's a better way of dealing with that. But I'll come on to that. I'm going to start with the challenge to the judge's conclusions as a matter of law. So just to begin by recapping what the issue is that we're talking about. Following the declaration of the dividend, Rockrose wrote off a sum of 53.7 million, which CS9 owed to it in respect of a premium liability, and that's common ground. The judge held that CS8 was ultimately liable for the whole of that sum, with the consequence that the write-off of that sum constituted consideration to CS8 of the amount, which was 53.7 million, that figure and the figure of 39 million, which you sometimes hear, is the same number. The 39 is the sterling, the 53.7 is the US dollar equivalent. And you get that finding at paragraph 250 of the judgment, which my learned friend Mr. Nash took you to yesterday. Now, what that finding amounts to is that the write-off of the premium liability constituted consideration to CS8, whether the transaction was the dividend alone or the wider transaction. Now, what the appellants say...
Sorry,
yes.
Did the judge put it in those terms?
She didn't put it in those terms expressly, but that, in my submission, is what she said amounts to.
Well, which paragraph is it? 250?
It was 250. Yeah, that's at page 193 of the...
We were taken to
bundle.
the first sentence of that.
Yes.
We were not taken to the rest of the paragraph, which isn't very clear, but I think the focus yesterday was on the first sentence.
Yes. Well, I'm very happy for you to read the whole of that paragraph. Perhaps we should.
I'm sorry, I wasn't keeping up. Which paragraph?
It's paragraph 250, 250 on
Thanks.
page 193. The rest of the paragraph is really about an issue that fell away after the trial and doesn't arise.
Okay, so should we be, for practical purposes, ignoring those last, the
yes.
second and third paragraphs?
Well, anything from the words "I am also"
Sentences.
Yeah. in paragraph 250 you can ignore.
Thank you.
Now, I do appreciate in that first sentence, the judge does say at the close of the sentence of which the dividend formed part, but those words aren't necessary in my submission, but for the conclusion. Put it a different way, that conclusion would have stood whether or not those words were there.
Well, I don't understand that. I mean, of which the dividend formed part qualifies as part of the arrangement.
Yes, but the important finding is the first two lines, it was consideration received by UKCS 8. She'd found that was consideration received as part of the wider arrangement. But my point is that even if she'd reached a different conclusion, which is the transaction was only the dividend, that conclusion wouldn't have been affected.
But that's maybe right, but it may be completely wrong, because we've had all sorts of arguments about the different cases of a dividend and the Sequana decision, and whether you can give consideration for a dividend and in what circumstances you might agree to it. She's not considering any of that. She's considering it from her end of the telescope, her lens, to use my lens expression.
Yes, well, I will go into those cases, Sequana, and the other cases. If you're against me on that submission as to the width
I'm
of
not
what the
for you
judge...
or against you, I'm just listening to you.
Yes, but put it a different way. If it turns out that you're against me on that, what I would say is to invite you to uphold that finding as applicable to the dividend alone. If that's what this court decides, that the transaction was the dividend alone, then
Yes. Then what?
Then-
what do you say?
then what the judge says in 250, ignoring the words of which the dividend formed part, should be upheld. So in other words, you'd read that sentence as if the final bit wasn't there. Or by UKCS 8, pursuant to the dividend. Or as part of the transaction. So in other words, my lord, if you're against us, or if you're against me on my primary submission as to the proper interpretation of that sentence, then I'd invite you to uphold the judge's conclusion that that the 53 million write-off was consideration flowing to UKCS 8 in any event, even if the transaction is only found to be the dividend. But my primary submission is that what the judge says in that paragraph is wide enough to support that. Now, what the appellants say is that the judge was not entitled to make that factual finding because the write-off was irrelevant as a matter of law. And my learned friend addressed you first on the premise that the transaction at an undervalue was just the dividend, then on the premise that the transaction at an undervalue was the wider transaction. But both of those arguments depended upon him establishing that the decision in the Court of Appeal in Sequana is authority for the proposition that consideration can be taken into account only if the terms of the transaction provide for the company to receive it. And that submission was not limited to dividends. It was said that it applies to any transaction. Now, Sequana doesn't support that proposition or go anywhere near that far. If we could go back, please, to Sequana at tab 1616 of the authorities bundle, page 415. And it's paragraph 35, which we've looked at before. If I could ask you to read 30, remind yourselves of what 35 says, please.
Yeah, I think we know those three questions.
So you see from that that the Court of Appeal in Sequana was concerned exclusively with section 423(1)(a), which is equivalent to section 238(4)(a). We can go back to one or both of those provisions to remind ourselves.
We don't need to do that.
Thank you. So the question in Sequana was whether the dividend alone, in and of itself, was a gift or a transaction for no consideration under section 238(4)(a), or the equivalent under section 423. So unlike the judge in this case, the court was not asked to decide whether the benefit flowing to the company, apart from the dividend, could constitute consideration under section 238(4)(b). Now that provision is concerned with a situation in which there's said to be reciprocal consideration, and the court's required to assess the relative value of that reciprocal consideration. And section 238(4)(b) doesn't refer to terms. It's not drafted in the same language as 238(4)(a). So that was the task of the court in Sequana. And all it decided was that the company doesn't receive consideration for a dividend within the four corners of the dividend itself. And you get that. I know we've looked at this before, but just remind ourselves. It's paragraph 50 of the decision at page 419. So that's all that the court decided in Sequana. And that finding didn't turn on the terms in which the dividend was drafted. It's really between F and G in paragraph 50. If and when a company pays a dividend to shareholders, the terms of the dividend do not provide for the company to receive any consideration, nor will it receive any consideration. That's the important bit at the end, nor will it receive any consideration. Now, contrary to what my learned friend suggested yesterday, the court clearly isn't, in that passage, laying down a rule of general application that if the terms of a transaction don't provide for a company to receive anything in return, that in and of itself means that the transaction is necessarily one for no consideration and therefore must fall within section 423(1)(a). It's just not what's being decided in paragraph 50. The decision doesn't go anywhere near that far. Now, if the court had purported to lay down a rule of that width in Sequana, it would have been contrary to the House of Lords decision in Brewing Dolphin, which I'll come on to briefly. Now, my learned friend noted that the Court of Appeal in Sequana, in this passage, didn't articulate a rationale for what he said was this general rule that it stood for. And that's a strong indication that the Court of Appeal wasn't in fact laying down a rule of anywhere near that width. My learned friend speculated as to what the rationale for such a rule might be, namely that an insolvent company shouldn't be able to reduce the quantum of a claim under Section 238 by the value of collateral benefits which it received. Now that isn't really a rationale, that's conclusory reasoning, and there's no good reason for that conclusion. And the reason I say that is that the vice at which Section 238 is aimed is a company depleting its assets by entering into a transaction under which it gives away more than it gets back, subject, of course, to the defence in Section 238(5). Now, there's no reason to ignore what the company does in fact get back. Whether or not what it gets back is provided for by the terms of any instrument that the court may decide.
I mean, this is all, it's all very esoteric. And the words of the section are the words of the section.
Yes.
The company enters into a transaction with that person for consideration, the value of which is significantly less than the value of money's worth of the consideration provided by the company. I see, which doesn't include the words in A.
Yes, well, that's
Yeah. What do you make of the point that A and B are framed as alternatives? If either
yes.
A or B.
Yes, well, there's a couple of points there. In a situation like ours, where it's contended that there was reciprocal consideration, more than one party to that transaction, or more than one party at least, gave consideration, then that necessarily engages B. All that was being argued in Sequana was whether a dividend fell in the terms of A.
But it could have been B.
I mean, there could have been an argument run in Sequana that consideration was provided. I mean, there wasn't, but if that argument had been run, then the analysis would have to have taken place under B, possibly as well as A.
But I mean, we can't read these authorities as deeds, which you seem to be doing. I mean, Sequana says what it says, and it gives the impression that in the context of A, not B,
yes,
you need to have terms that provide, because the section says, enters into a transaction on terms that provide for the company to receive no consideration.
yes.
It says that doesn't have to be construed as a deed, it can be generally applied, but there must be such terms. Surely that's obvious.
Well,
there have to be such terms. If there are no terms, then that section's not engaged.
well, I'm not sure. There's a couple of points there. I mean, first of all, this case, there was consideration. It said there was consideration flowing both ways, so we're in the territory of B rather than A.
Well,
as I understood, sorry.
Can I just ask that question again? As I said, A and B are framed as alternatives.
Yes.
And by the way, all that 4 is doing actually is determining whether there is a transaction that's an undervalue.
Yes.
Not anything else. And it reads to me as either A or B, as a
Yes.
matter of statutory interpretation.
Well, as I understood the way the argument was put by the appellants yesterday, it was that in each and every case, unless the terms of a transaction provide for consideration to be received by the company,
There is no consideration,
well, there is no consideration,
which you can take into account.
but that necessarily means that the transaction or the arrangement falls within A. That was the proposition that it was being said Sequana stands for.
I mean, speaking for myself, I can see that, as my lady implies, there's an extra step, which is whatever 4 means, does that govern the approach to Section 2383 and so on.
Yeah.
But leave that aside. In terms of B, what you get in B is the word for. So the company enters into a transaction with that person for a consideration. Now, it doesn't use terms, but again, you have to look at B to see what the company entered into the transaction for.
Yes.
And if the dividend is declared, but that is not done for the repayment of whatever, that doesn't seem to count for B.
Well, that I largely agree with, and what for means was what the question that Brewing Dolphin engaged with. You know, what's the nexus that one needs to establish? And I am going to come on to that. The only point I'm trying to address at the moment is the appellant's submission that unless a transaction, the terms of a transaction provide for the company to receive consideration, then the consequence is that that transaction necessarily falls within A, and that is what it was said Sequana stands for. That's the proposition Sequana stands for. And the extent of my submission on this point is simply that that's wrong. That's not what Sequana stands for, and neither is there any warrant in the words of A to reach that conclusion. So what does need to be established, I'm going to come on and address. So putting Sequana to one side, if the judge was right and the transaction included the write-off of the premium liability, then the value of that write-off is obviously, in my submission, to be included when calculating the undervalue. If the transaction includes the premium write-off, it follows it must be included, must be taken account of when calculating the undervalue. Now, even if we're wrong about that, the write-off is still to be included because it comprised part of the transaction consideration. So this is a separate point. In other words, even if the write-off of the premium liability fell outside the perimeter of the transaction with a capital T, it may still be taken account of when calculating the undervalue because it comprised part of the transaction consideration, even if not part of the transaction itself. And this is where Brewing Dolphin comes in. And this decision is fatal to my learned friend's argument that consideration must, in all and every case, be provided for by the terms of the transaction. Because as we all know by now, in Brewing Dolphin, the Court of Appeal found the transaction was simply the share sale agreement. And the House of Lords didn't demur from the Court of Appeal's decision as to what the transaction was. But it still found that consideration flowing to the company otherwise than under the terms of the SSA, the share sale agreement, which is what the Court of Appeal had decided the transaction was. So in other words, consideration flowing to the company under a different agreement still constituted transaction consideration, so was still to be taken into account.
On remedy.
Well, when calculating the undervalue.
Yeah, on remedy. What's the undervalue?
Yes, what is the undervalue? Yes.
Which needs to be remedied.
Yes, which is exactly what's being challenged by the appellant, that the judge wasn't entitled to take account of the premium write-off, because the terms of the transaction, they say, didn't account for that, didn't mandate that. Now, on that same point, my learned friend was wrong to say that the share sale agreement provided for the lease to be, this went to my lady's point yesterday, that he was wrong to say that the share sale agreement in Brewing Dolphin provided for the lease being the agreement under which...
I don't think he did say that.
Well, I hadn't quite, I was going to say, he said as a matter of implication or construction, that he was wrong to even go that far. There was nothing in the judgments, either at the Court of Appeal or in the House of Lords, to suggest that that could be implied or construed from the share sale agreement.
Well, what I think the House of Lords refers to Lord Justice Morritt's summary, of the facts, which includes a memorandum, heads of terms or whatever
Yes.
it was. And as I understand it, that was treated as effectively setting out the commercial deal.
Well, that was a one-sided document. As I understand that document, it was drafted by Brewing Dolphin.
Yes, but treated as establishing the facts by the court, as
Well,
I understand.
not really the facts, the broad concept of what was intended, at least on the part of one of the parties to that arrangement, so Brewing Dolphin. I mean, the whole point of the arrangement in Brewing Dolphin was that you'd have two separate agreements in order to avoid unpleasant tax and regulatory consequences. So it would be surprising if the SSA had contemplated or had provided by a matter of construction or implication that consideration was going to flow under a different agreement. Can we go to the reasoning in Brewing Dolphin at paragraph 20? This is in the authorities bundle behind tab 4, page 51. And it's at G. If I can ask you to read, please, to the end of that passage and down to the first line on the next page. Now, there's nothing in that passage that suggests, still less mandates, that in all and every case, the terms of the contract with A must provide that B enters into a contract. Using the example the House of Lords used in that passage, neither is there anything in that passage that says that the consideration must be received pursuant to a collateral contract. There's nothing that mandates that. The important point is that consideration is received. And I'll go on to what the House of Lords says the test is. But if we could just skip briefly to the way the judge interpreted this passage. So this is in the core bundle behind tab 7 at page 188. This is paragraph 234. It's the first sentence of 234.
$224.
34 on page 188. So that, respectfully, was an accurate summary, but by the judge, of that passage, which is the crucial passage in Brewing Dolphin. And the crucial sentence in that passage we just looked at in Brewing Dolphin, between G and H, so page 51 of the authorities bundle, is this. The identification of this consideration is, in my opinion, a question of fact. But that's the crucial reasoning to be got from that passage.
But,
Yes.
I mean, yes, it's a question of fact, but what you're trying to identify is the consideration for which the company has entered into the transaction.
Yes.
The previous sentence.
Yes.
The terms may be relevant to CH. And then paragraph 21, on the facts of this case, it is, in my opinion, plain that the consideration for the BSL shares was. And,
Yeah.
I mean, this may or may not matter, but does the judge engage with the question of whether take it by stages, whether A, the dividend was for the write-off of the pension liability, or B, the wider transaction was for the write-off of the pension liability?
Well, she certainly concludes that the write-off wouldn't have happened without the other steps. I mean, that was the overall thrust of the judgment, that all of these steps were bound up as part of one overall transaction, one overall arrangement, let's call it.
I mean, that is a slightly different question, isn't it?
Yeah.
I mean, perhaps if you take a really wide approach to transaction, it's all wrapped up together. But subject to that, the mere fact that something wouldn't have happened but for something else happening doesn't tell you about the for point.
Well, there has to be a relation between the two things.
A but-for relation or something more?
I mean, a but-for relation would be enough. That would be enough.
Is that consistent with the word for?
It is, yes. I would submit that is consistent with the word for. I mean, what one has to have happened as a result of the other, and if one wouldn't have happened without the other, as the judge found in this case, that satisfies the test. That must satisfy the test.
It might be completely different transactions, but they might be linked in some other way that means they wouldn't actually have happened. It doesn't mean that the consideration given in part of the other transaction is for a dividend or whatever was declared. I mean, you can't, I mean, this all turns on who's right about the ground one. If you're right about ground one,
yes,
this doesn't much matter. If you're wrong about ground one, this might matter a lot.
Yes, absolutely.
Because what I think my lord is asking is whether the judge ever asked herself the question, and she might well not have done, since she'd already concluded that the answer to ground one was as she found. So she might not have concluded in the alternative that even if the dividend had been the transaction which she was addressing under section 238,
yes,
the position was that the consideration for the dividend was the pension set write-off.
yes.
I mean, I mean, you may tell me I'm wrong. Did she? I mean,
Yeah, I mean, in fact, the last paragraph of 234 rather suggests that she didn't. She was answering the question in the context of the wider arrangement.
Yeah.
I mean, you say she did.
I say that what she said certainly in 250 is her doing that. And going back to the earlier submission, if the court doesn't agree with that submission, then this court would be able to uphold the finding that consideration was received in the form of the premium liability write-off, even if it finds that the transaction constituted a dividend alone. That I think is my Lord's point. When this point becomes important is if you're against us on ground one.
It might be said, well, 2, 3, 4 is all very interesting, but we know there was a transaction to undervalue here. And so really what matters is what you do pursuant to 2383. Now, there it's said against you, well, 2384 leads on to 2383, but you might alternatively say it's a different exercise.
I think the relevance of that is this, that if you're with me on what the extent of the undervalue is, then the starting point under 2383 is that. So in other words, if you're with me that you take account of the whole premium write-off, your starting point when you get to 2383 is that the undervalue is only 30 million, and the question is, do you make an order in that amount or something else? So that's the way it flipped. But it's going back to the earlier exchange. It's a purely legal point. What was the? Is the court able to conclude that even if the transaction is just the dividend, then as a matter of law, is the premium liability capable of constituting consideration for that transaction? The test of that is Brewing Dolphin.
Can I just talk that through for a moment?
Yeah.
So, suppose for the sake of argument that the transaction is just a dividend, and suppose for the sake of argument that the dividend was not paid for the pension write-off, then that all falls into how you assess Section 2384. Now, when you come to Section 2383, that tells the court that, subject to what follows, the court is to make the order that it thinks fit for restoring the position to what it would have been if the company hadn't entered into the transaction. Now, arguably, the restoring to what it would have been sounds more but-for-ish than 2384 does.
Yes. When you get to 2384, I beg your pardon, 2383, the court has just got an unfettered discretion, essentially to reflect the justice of the situation and to restore matters to what they would have been if the transaction hadn't happened, but taking account of all subsequent events. And there's no doubt that the premium liability write-off becomes relevant at that stage, even if you're not with me on whether it becomes relevant at the undervalued stage. The reason, as I say, that this argument matters is the starting point when you get to 2383.
But in terms of the structure of the legislation,
Yes.
the fact that the court does have that discretion in subsection 3 might inform the interpretation of other provisions. And for example, the point I made earlier that 4A and B are expressed as alternatives, you could view them as just triggers which give a basis for the court to exercise that discretion if and to the extent it thinks fit.
When the court gets to the stage of, if and when the court gets to the stage of 2383, I wouldn't accept the proposition that it's constrained or it's the way it exercises discretion.
No, I wasn't suggesting that it was.
Right.
More that allows an appropriate, just result, taking account of all relevant circumstances.
That's right. So like I said in answer to my Lord Justice Newey's question, the reason it's relevant is the starting point when you get to 2383. If I'm right about that, I start from a much better position because I only have to persuade you to reduce the order by 30 million, not by 84. We've heard a lot about the judge's finding that one of the concepts of this arrangement was, or rather included, terms that it should be a cash and debt-free sale. That was part of the basic concept of the arrangement in this case. And just pause to say that's not the same thing as the purpose of the deal. The purpose of the deal was to break the impasse and to put CS8 in the hands of a strong parent, etc., etc. But the basic concept of that deal involved a cash and debt-free sale, which in turn meant a reciprocal release of debts between the seller's group and the company's group. And we've seen the parts of the judgment in which the judge acknowledged that and the evidence of Mr. Mazzagatti, which supported those findings. Now this is where we come to the link, the necessary link, the 4 point that my Lord made in order to satisfy the test in 2384B. Now, the dividend and the write-off were both intended to give effect to that basic concept, the words a cash and debt-free sale. And in that important sense, they were provided in return for each other. So going back to the language of 2384B, the write-off was consideration for which CS8 entered into the transaction. One would not have happened without the other. It was only because CS8 was leaving the group, the Rockrose group, that the premium liability was written off. And as I say, that's so whether the transaction was the dividend alone or the wider arrangement. That's all I was going to say about the legal objections to the judge's finding, unless I can assist any more with that part of my argument.
Okay.
Yes, then there was the point that my learned friend Mr. Nash made earlier about Brewing Dolphin, the point about the loan being brought into account, even if it wasn't part of the transaction. So that really fortifies my submission.
Yes, but that is definitely brought into account at the remedy stage. That, I mean, arguably, your Brewing Dolphin takes different approaches here. It treats the lease consideration as part of the consideration. But then, in relation to the loan, it looks at that at the remedy stage. It doesn't treat that as part of the house rules. Don't treat that as part of the consideration.
Yes,
which is possibly a bit of a puzzle.
Yes, but in this case, my submission is that you can consider this at both stages, the premium write-off, because it's consideration within section 238 4B, and it becomes relevant at the remedy stage. So moving on to the factual challenges, and I'll start with what should be done about these, excuse me, as a matter of procedure. Now, there are three separate points which have become a little bit conflated. The first point is that we have the benefit of a factual finding, which is that the premium was entirely chargeable to UK CS8. And we get that from paragraph 250 of the judgment, the bit we looked at a short while ago. Now, in their original appellant notice, and nothing is...
Do you mean premium?
What do I mean premium? The 53.7 million.
The pension premium.
Pension premium, exactly. So that they've raised 5 factual challenges to the judge's conclusion in that respect. Now, these are freestanding challenges, which, as I say, have always been there. But they don't depend on the new evidence. They've always been part of the appeal. Now, in respect of those, I say that the appellant should either give those up or pursue them now. So that's the first factual point. The second point is the new evidence, and the question there is whether that new evidence would have driven the judge to a conclusion different to the one that she reached in respect of the whole of the premium liability being a liability of CS8.
That's not quite formulation, is it? You don't have to go as far as to show it would have driven. You have to show that it would have been reasonably capable of giving rise to a different result, or likely to give rise to a different result, or influential. I can't remember the words, but it's would have driven.
No, it's
the
not.
judge.
It's not quite that high.
Yeah.
I mean, we can go to it in Ladd and Marshall if you
Yeah,
like.
but we don't need to.
No.
But
it's
can
that,
recite Ladd and Marshall by heart.
yeah, that's what it's in that territory, that part of the test. Now, in order for this issue even to get off the ground, the appellants need to establish that that new evidence is admissible, and the serious problem they face there is the Al Sadiq and Deckard case, which I'd like to go to.
What's it say?
Well, it's easier, I think, to read the passages. It essentially says they're out of time. But I need to make that good by reference to the case. So it's at tab 19 of the authorities bundle, page 1005. Sorry, yeah, 1005.
In the tab 19 of the authorities bundle, I've got AFM 1932.
That's my mistake. I should have said the application bundle, not the authorities bundle. So it's 1005 of the application bundle.
1005 of the application bundle.
Yes.
What do you call the application bundle?
That's the bundle that contains the application to put in the new evidence.
Oh, new evidence.
Yeah.
Okay. Yeah.
So that's the case. The first relevant passage is at paragraph 143, page 1057. So it's about in the middle of that paragraph, just above C. Evidence which becomes available. If I can ask you to read that, please, just down to where it starts to cite the authorities. And then also paragraph 144, down to mention of the case Imperial Chemical. And then the final, sorry, if you finish reading that, the final part of this judgment I'd ask you to look at for now is at the top of page 1058. There's reference to a decision, but that's not important. It's 5 lines down I'd like you to look at, please. If fresh evidence becomes available. Now, the short point on this is that the appellants didn't do what they ought to have done in accordance with this decision. What they did was, between the end of the trial and finalisation of the order, following judgment, they wrote to us and invited us to write to the court. I can show you that letter, but perhaps there's no need to. But for the reference, it's also in the application bundle at page 259, paragraph 4.2. And we declined that invitation, essentially because the pension documents didn't change anything. This was all before the order had been filed. This was, in fact, before the draft judgment had been handed down. Now, after we'd refused the invitation, what the appellants ought to have done, in accordance with those passages of Deckard I've just taken you to, was apply to the lower court for permission to admit the new evidence. But they didn't do that. what they did do, we don't have this email in the bundle, but it's quoted verbatim in the first witness statement of Mr. Ashley for the appellants. That's at application bundle tab 4, page 44. So it's paragraph 50. If you could just read, this is the text of what the appellants did, the email that they sent to the court.
Sorry, which paragraph?
I beg your pardon, it's paragraph 50
Yep.
on page 44. So the points to note from that email are that the appellants didn't ask the judge to admit the pension documents, still less did they apply for permission to rely on them. They didn't even enclose the pension documents. So what all of that gets to is that in terms of applying to the lower court to admit the new documents, the appellants have missed the boat. And where that leaves the appellants is that they could ask this court to admit those documents, and if they're successful in that, ask this court to remit the question of what, if any, difference they make to the lower court. But Deckert shows that this court generally won't do that. You saw that passage I took you to that said that it's much more difficult in the Court of Appeal. It actually went further than that.
What I don't understand about all this very compelling stuff is that if we completely overturn the judge
Yes.
and say she was totally wrong, lock, stock and barrel, let's say,
On everything.
well, on everything enough to overturn on ground 1 and ground 2, so
Yeah.
that she was wrong and looked at the thing through the wrong telescope. There is a necessity for somebody to look at it through the right telescope and to consider remedies, which is a very broad question under
Yeah.
section 2, under the various sections following 238. What proper remedy is appropriate in this case once you've looked at it through the correct telescope?
Yes.
And the suggestion that in that analysis the court below cannot take into account whatever evidence the parties decide to adduce, looking at the matter through the correct telescope, is just unrealistic. Just tying the hands of the court in a way that we personally, I would find very, very undesirable.
I beg your pardon.
Because you may be entirely right that there was consideration for this dividend, which ought to be taken into account, and that the therefore the restoration to restore the estate of the debtor company might be very much less money than they say, and to tie the hands of the court below, to whom it's going to be apparently by consent referred back, seems to me to be on some technical ground that you're now advancing, seems to me quite unappealing.
It's not really tying the hands, though. I mean, I well accept the proposition. In fact, I positively advance the proposition that the court below has got an unfettered discretion, is the word that the textbooks use, when fashioning remedies. It's something different going on.
Just want to cut out 4 documents from that unfettered discretion.
Well, no, it goes to the starting point at which the discretion is exercised. This was the exchange I had with my Lord Justice Newey. And the judge has made a finding of fact that the whole of the premium liability was a liability of CS8. And that, at the moment, when this case gets remitted for remedies, if it gets remitted for remedies, that's the factual starting point for the unfettered discretion to be exercised. What the other side are saying is that they want to undo that factual finding that CS8 was liable for the whole of the premium liability. And as I say, they've got 5 factual challenges to that, which are in their appellant's notice, and I've got no issue with. I'm prepared to answer those. What I do have an issue with is them saying that they want to attack that finding on the basis of new evidence. And they can't do that. I mean, first, they can't do that because of Deckard. Second, even if they could overcome Deckard, they couldn't do it because of Ladd & Marshall. And that's not us trying to be difficult or trying to keep out relevant. I don't actually accept the evidence is relevant, but put that to one side. That's just a matter of law. We're perfectly entitled to rely on these decisions in our favour, and they're insuperable for the appellants.
So what if we decided that the judge conducted her analysis of the case on a completely wrong basis, and therefore all the findings she made were on a completely wrong basis? I'm not saying really we're asked to do that, but if we did, surely we can send it back for a judge to hear the case again with new evidence.
Well, yes, but that's an extreme case. I mean, that if posit those facts, then there is probably room in Deckard, and there certainly is in Ladd & Marshall, for you to admit that new evidence, send it back to the judge for her to reconsider in light of that.
So really what you're saying is, by holding this sword of Damocles over our head, you're saying that in order to make common sense of all this, if we allow the appeal, we should send it back and admit the new evidence under Ladd & Marshall?
No, I'm certainly not saying that. I'm saying that in the extreme circumstances that you posited, I'm saying that option might not be ruled out. That isn't our case.
But it all sounds terribly unfair to rescue from a judgment. I mean, this is all on the assumption that she was wrong. If she was right, that's fine. But if she really went badly wrong in this case, to rescue one finding of fact on a remedy, which she hardly considered because she wasn't really considering remedies, to rescue a single finding of fact and erect it into absolutely tying the hands of further determination is just counterintuitive for me. I mean, we want to do justice here. If the appeal fails, we want to do as much, succeeds, we want to do as much justice for you as we do for the other side. We want to make sure that whatever order is made is the just order that should have been made, taking into account everything that should have been considered. It's to as I say, to elevate one finding of fact and say that's absolutely got to be sacrosanct. I mean, even if you're right as a matter of strict law, terribly counterintuitive. I mean, I can't see why you just don't all agree that if the appeal's allowed on grounds 1 and or 2, it goes back for the judge to consider the matter again on whatever evidence everybody wants to produce, to see what the just solution is, because this just solution will be a great deal more complicated, as it seems to me, than this one finding of fact.
Yes, but this is a very important finding of fact, and the...
Well, it's because it is, but you might have even better points.
Well, look, at the moment, we've got that finding of fact in the bank, and the point about broad justice, I don't accept those points apply with...
No, you don't accept broad justice. You want to erect this finding of fact as the final solution. Okay, anyway, I've got the point.
Yeah. I mean, certainly what the learned friend proposed in his exchanges with you yesterday would be completely unfair to us. As I understood what he proposed, it's that the court follows your proposal and remits all of this to the judge, including, as I understand it, the application to admit new evidence.
Well, I don't think we can do that. We have to deal with the
Yes.
finding to admit new evidence.
Yes, and I've made my
It's
point.
made to us, and you say it shouldn't have been, and we should reject it, and we will consider that.
Yes, and I've made my points about Deckard, and there's nothing else to say on that. But what I haven't made my points on is Ladd & Marshall, So if the course is going to be that this court considers whether to admit that evidence, I have to make my submissions on Ladd and Marshall. I'm not sure of the right. I'm in the court's hands as to the right time to do that.
Now.
Okay. Well, I'm prepared to do that now. Could I just first of all complete the last submission I wanted to make before coming to that? The course my learned friend proposed yesterday, as I understood it, was that if you're minded to admit the evidence, the new evidence, having applied Ladd and Marshall, then the question of the premium write-off goes back to the judge alongside the question of remedies. And my learned friend said, look, I don't want it to be argued in that hypothesis that we're stopped from coming back to this court and pursuing the permission to appeal the judge's original factual findings. I mean, that seems to me to be a completely unfair proposal to us. Great for them. Okay, so I think, my lords and lady, if we're content that if grounds 1 and 2 succeed, then the case is remitted.
Yes, if grounds 1 and or 2, I suppose. Or I suppose they're dependent on each other. 2 has to win.
Yes, then we accept that the question of remedies,
yes,
alongside the pension documents, alongside the question of the premium liability write-off.
Question of remedy.
Yes.
Alongside premium
liability write-off.
Yes. Is remitted.
It is remitted, but not, and this is the point I was just making, not that in the event the appellants don't like what the judge decides, they can revive their appeal against our original factual findings before this court, which is exactly what I understand my learned friend was suggesting yesterday.
Very confused by that.
I'm a bit confused by that.
That wasn't my understanding. All I thought Mr. Venkatesan was saying yesterday was we don't want the fact that our appeal on this particular aspect hasn't been determined to mean we're stuck with the finding when we go back to the judge.
Right. In that
This
case,
is, my lord, that's precisely what
yes.
our position is.
In that case, I'd misunderstood that.
So, just to be clear what you're content with, we are content that if grounds 1 and 2 succeed, then the question of remedy alongside premium liability write-off is remitted to the judge.
Yes.
Yeah. No, and we don't have to deal with the Ladd and Marshall.
No.
Perfect. And then the application to adduce new evidence. I mean, plainly, if we're remitting something to the judge to decide, she will take into account the evidence that she heard before, and no doubt the findings she made on it, but it will be open to both sides to apply for evidence to be, new evidence to be adduced on points that arise because of the decision going back to her.
Yes.
I mean, it'll be at large, because I mean, the reason I was a bit rough with you, Mr. Hubbard, is because this exercise, I happen to have done it myself at first instance. This is a complicated exercise, remedies, and
Yeah.
she didn't do the complicated. I mean, no criticism because she made a clear decision in your favour. But if there has to be an exercise, it is an exercise, as we see from the section itself, of restoring the position to what it would have been if the transaction had not occurred,
Yes.
which is super fact intensive. And it will, both sides will have lots of things to say. I mean, you know, they will say plainly that it's the whole premium, but you will say, well, that's jolly unfair because this would never have happened. There would never have been a set-off. The thing wouldn't have happened in this way without it. But you may find yourself in some difficulty with that submission because the evidence was sort of, this was an afterthought, and they'll no doubt try and hoist you with that. But the point is, ultimately, it's a new situation that the court has to deal with. And it's very unfair to have sort of both sides fighting with one arm tied behind their back based on a judgment that was actually on the wrong premise. If it were, if it was, if not, not. But I mean, I think you would find it came back to haunt you. I think you actually will be the beneficiary of the ability to argue everything, or you may be, because there are some findings there that, you know, anyway, may look different. I mean, just I'm keen to get a just solution, not to punish people on either side.
Yes. Okay. Thank you.
I mean, I think we'll have in our judgments to make sure we're very clear about the exercise the judge is doing if we do allow the appeal.
Yes. Yes.
But I think you can rest assured we'll think very carefully about that, and we'll try not to cross any of your red lines if we can avoid it.
We're grateful.
And if
for
so,
that.
we'll say what red lines we're crossing and why.
Yeah. We're grateful for that. Thank you.
Okay, thank you. Good. I gave Mr. Allison the opportunity to sweep up.
Well, like him, I will decline the broom.
Don't say you weren't asked. Thank you very much. Yes, Mr. Allison.
If it please the court, I think in view of the very latter part of the exchange that just occurred, that we are not in a timing problem, which I'm sure will be of a delight to the court, because it's our understanding we now don't need to go near the second part of ground 3.
No, you only need to go down to the first part of ground 3.
Precisely.
And yes, ground 1, ground 2, and ground 3A. Yeah.
And I think will be roughly 45 minutes between the two of us, subject to the court.
4:15 is your only deadline.
Well, we'll see if we can beat that, but thank you.
But it really is a deadline.
Of course.
I'm afraid. I've got a swearing in.
Ground 1, then. As the court knows, we say the learned judge failed to apply the correct legal principles when determining what the transaction was. 2 short points in reply from what we've heard from my learned friends. First, nothing that my learned friends said yesterday or this morning identified with respect to the error of law that we have identified within the judgment. And again, very happy to go back to the paragraphs if the court will be assisted. They're probably only too well known by the current time. It's paragraphs 231 and 232, which is page 186 and 187 of the judgment of the bundle. In particular, the last sentence at 231 that we focused on in opening. And within these paragraphs, the learned judge makes 2 findings. Firstly, that the dividend was merely an afterthought. So that's her key finding number 1, to give effect to the cash-free and debt-free sale. And second, the judge finds that the transaction is all the linked steps to facilitate the sale. And it is that because the dividend is inextricably intertwined with the sale. Now, there's no further analysis. In other words, the judge assumes and treats that link as sufficient to constitute the dividend merely part of a wider transaction, which then forms the transaction for the purposes of Section 238. Now, of course, I won't repeat what I said on the authorities yesterday, but as the court knows, we say that's an error of law. It's a wrong application of the requirements of the statute. It's a wrong search for the meaning of transaction according to those legal principles. So the approach of the judge we see there is contrary to the language of the statute as interpreted in the authorities. The provision that we spent a lot of time on yesterday focuses on the actions of the company. The company has to enter into the transaction. It's common ground here the company is not a party to the SPA. It's common ground that there is no reference in the SPA to any declaration of dividend. It's recognised by Mr. Nash this morning that all the company was the subject of the SPA. And indeed on the judge's findings, that is hardly surprising, the dividend being an afterthought. And the sole act of the company was the declaration of the dividend. Now we therefore say on a normal and ordinary meaning of the statutory provision, the transaction here is the dividend. The point that we make side by side with that is, as the court knows, it's also common ground that there's no suggestion that the company, I'm calling it the company rather than UK CS8 in view of the indications, that's rather lengthy, there's no indication in the evidence or the findings that the company instigated, arranged or procured the other agreements such as the SPA. It came late to the party as an afterthought. And we therefore say that ground one should succeed. And we say that's consistent with the authorities. Subject to the court, I'll then move to ground two. The court has our submissions from yesterday on why we say the learned judge failed to ask the right questions when addressing the statutory defence, and we say that means ground two should succeed. Now I'll seek to avoid repeating what I said yesterday, but there are a few points from Mr. Nash's submissions that I should respond to. And I think our headline points can be distilled into two related reasons why we say the respondents are wrong, and as we submit, we can succeed on appeal without challenging the factual findings of the judge. Now the first point is that the learned judge asked herself the wrong question when considering the statutory defence. Now the main error, we say, is an error of law in that the learned judge did not anywhere grapple with what we called yesterday the unnecessary cash removal point. And I'll just explain what I mean by that.
I don't remember calling it that yesterday.
Oh, my lord, if I didn't,
Unnecessary cash removal point, you mean?
the dividend. I mean the dividend.
Okay.
Maybe one word is a lot easier. Maybe I can start within the part of the judgment dealing with Lim 3, just to show the court what I mean before I go back to the general point that frames all the discussion of the statutory defence. That's page 203 of the bundle. At the bottom of the page, paragraph 268B. And this is when the judge deals with the submission that the dividend itself was not objectively justified because the company was insolvent, so that removing its cash before sale could not possibly have benefited the company. And the judge's conclusion to that was that the submission that we made concentrates impermissibly, as I have held, on the dividend to the exclusion of the wider transaction. So that's the premise for the judge rejecting our argument in relation to the removal of the asset by the declaration of the dividend. Now we say that that reveals keenly, there are other places as well which I'll show the court in a moment the error of law we say the judge has made. Because if we are correct, firstly, under ground 1, then the dividend is the transaction. And the consequence of that is that the dividend is the focal point for the statutory defence. In other words, what Section 2385 would require is consideration of whether there were reasonable grounds for believing that the dividend would benefit the company, not as the judge considered whether the broader sale would benefit the company. What the statute asks for is whether there are reasonable grounds for believing the transaction, not something else, would benefit the company. And we say that's entirely understandable, both as a matter of language of the statute, number 1, and 2, in view of the statutory purpose, number 2, which is to allow the recovery of assets by an insolvent company to uphold the principle of pari passu distribution. So that's the way we put the case. The same point put a different way, and I'll very respectfully adopt it, is adopting the words of my Lady Justice Falk and my Lord the Master of the Rolls this morning. It's important to identify the lens through which the statutory defence is being considered. And the failure of the judge to consider whether the statutory defence was satisfied on the basis of the dividend being the transaction means that the judge is looking through the wrong lens. And there's no consideration in the judgment, for the reason I've shown you within this paragraph amongst other points, as to whether the dividend itself was objectively beneficial for the company. And that's the question that should have been asked. And as observed this morning, it's not a question the judge did ask. And one can readily understand why the judge didn't ask that, whether in relation to limb 3 or indeed any other limbs of the defence, if one goes to paragraph 252, page 194. Now, I know the court's seen this already, apologies for returning to it. But this is where the judge, in particular in the very last sentence, having considered a submission of Mr. Nash that even if the dividend's the only relevant transaction, the defence can include a wider inquiry. We say no, as I've said already a moment ago. But the judge makes clear that whether Mr. Nash is right or not about that, since I agree with him that the relevant transaction is the wider arrangement encompassing the sale to FOIGC and all its associated steps, it is unnecessary to dwell further on the point. So that tells one clearly, which we also saw in relation to the specific finding in limb 3 a moment ago, that all of the inquiry of the judge about the statutory defence is viewed through the lens of the sale, not through the lens of the dividend.
You may be coming to this, but do you say it must follow that if the judge had asked herself the right question,
My lady, I do.
she would have concluded that
Absolutely.
the third limb was not met?
My lady, yes.
Okay.
Sorry, I'll quicken along.
Yeah.
So my next point was to be, if the statutory defence is considered through the right lens, then we say the conclusion is that the statutory defence is not available. And really, as the facts of this case actually, which were posited by my Lord Justice Newey this morning as an extreme case, in other words, you have an SPA first and a dividend later, is in fact the facts of our case as recognised by my Lady Justice Falk. The SPA in this case was entered into between Rockrose and FOIGC on the 15th of December. The company is not a party to the SPA. As observed this morning by my Lady Justice Falk, there is no condition precedent to the effectiveness of the SPA that the intercompany receivables are removed before completion.
And the dividend was declared on Christmas Eve.
My lord, it was 24th of December.
Which is the date of completion.
My lady, yes. Yes. So declared on the 24th of December, 9 days after the entry into the SPA, and completed then because on that date there was a waiver of, on the evidence, there was a waiver of one of the conditions within the agreement as found by the judge. That was the condition that FOIGC needed to post relevant security. Maybe I can just show the court that. It's page 316 of the bundle.
Which bundle?
I'm so sorry, the core bundle.
Yeah.
It's clause 3.2. So page 316, clause 3.2, which identifies when completion takes place, and it's 3.2.2, which was waived by Rockrose so completion could occur. So in other words, although the security for the obligations of the company had not been provided by FOIGC, what, to the extent there was any doubt about that, it was said by the judge that was waived so completion could take place. Now, no mention within the SPA, of course, of the dividend, no CP that a dividend is paid before completion can occur. And indeed, that's consistent with the findings of the judge, namely that the dividend was an afterthought, number one, wasn't even contemplated when this agreement was put together and the mechanics for completion were put together. And number two, the factual finding of the judge that the reason why the dividend was paid is that Rockrose and Mr. Mazzagatti, in other words, old parent and beneficial owners, did not want to leave the money within the company once it moved to a new owner.
Well, doesn't want to leave the receivable in place, really.
My lord, it comes to the same point. And Mr. Nash made clear this morning that he wouldn't quibble with the proposition that FOIGC, the purchaser, would have been delighted to have moved forward without the declaration of the dividend. There's no suggestion that FOIGC required a dividend before completion could occur.
Does 3.2.2 mean that Rockrose wasn't really tied in either? It could say, well, the sureties, blah, 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 haven't been provided. They're not going to waive it. Forget about the sale.
Theoretically, although Rockrose's position at trial was it had been satisfied and it was waiving it for the avoidance of doubt.
I see.
So that was the evidence given. The evidence given was that the bond offered, they believe, satisfied the requirements and they waived it simply for the avoidance of doubt. You know, we relied on that as a point in favour of purpose, and the judge characterised it as a lawyer's point on the basis that it was really just being done for the avoidance of doubt. So, coming back to the correct lens against that backdrop, we do say that if one poses the question that the judge should have done, if we're right on if we're right on ground one and even if we're wrong on ground one, was the removal of the 84 million, in other words, the declaration of the dividend, in the best interests of the company, looking at the company's interests? And no such question in our respectful submission was asked, because the focus was always on the wider arrangement, never the dividend. Can I?
Sorry, but you, just to be clear, you say it must follow that if the correct question was asked, the judge would have reached,
My lady, yes.
could only have reached one conclusion.
My lady, we do. We say if one stands back and asks what is the correct conclusion to ask, question to ask, namely whether a declaration of dividend by an insolvent company immediately before it is sold to remove a significant asset is in its best interests, the answer only posits of one result from its perspective.
And are you developing this any further, or shall I ask my question now?
I was going to turn to say that even if we're wrong on ground one, why we still say we win on ground two.
Can I just think then about what you've just said? I mean, the judge doesn't, I think, explore that question in her judgment. So let's suppose that the idea having been conceived of the dividend being declared, the company had gone to an insolvency practitioner. The insolvency practitioner had said, well, you better really think about this. You better think about what's in the company's interests. Can we work out what would have happened? I mean, might Rockrose at that point say, well, unless that happens, we're going to wriggle out of this agreement, and on that basis, the company won't get the benefit of the sale and purchase agreement, which is in its interest. Or you see what I mean? Are there permutations that have not been explored or not sufficiently explored in the judgment because the judge wasn't thinking in those terms?
I completely understand my lord's question. We say no because of the factual backdrop, including one, a purchaser that had not said the dividend needed to be paid, and two, no suggestion in the evidence of Mr. Mazzagatti or to the court that they wouldn't have gone through with the transaction but for the dividend being paid. They said they didn't want to leave the money there, but they didn't say they would otherwise have not gone through with it. So that would then...
But this question may come into starker relief if you win and the matter is remitted for an assessment, because the assessment of the remedy asks the question, what would have happened had the dividend not been paid, because that's what you have to restore. And there may be a suggestion on the other side that, I mean, this is what I said to Mr. Hubbard, is that, you know, he may want to say, no, there should be no payment because actually this would never have happened and the company would have been worse off still. I mean, I don't know. Maybe there was no evidence about it at the time, and maybe they didn't say positively the dividend, the transaction would have gone ahead anyway, but they may be wrong about that because it's maybe not quite so black and white.
Well, I think 2 points. One, we would accept that remedy would include a counterfactual inquiry.
Yes.
I'm not suggesting for a moment
Yes.
it wouldn't, but I think, two, we would still suggest that when one does that counterfactual inquiry, this sort of money going out the door from an insolvent company should only permit of one remedy when it comes to preserving the interests of the insolvent estate. But of course,
The whole thing is reserved.
no, of course.
Yes. Well, then you have to also answer the question about what, how the pension release came to occur.
My lord, yes. I mean, we recognise that issue 3 will, in essence, be up for grabs both of a as a matter of undervalue if you're not with us on the first part of ground 3, and more broadly perhaps as a question of remedy.
Okay. I mean, that all validates the decision, if I can put it that way, to remit if the appeal were allowed.
Then what if we're wrong on ground 1 and the transaction is the sale agreement? We maintain that the judge again has made an error of approach that vitiates the findings in that regard, because once more the judge hasn't asked the question whether a sale which involves the removal of 84 million by the declaration of a dividend was objectively beneficial to the company. And by that we mean that the judge has assumed that a sale in the abstract may be beneficial for UK CS8, and the judge has relied on that to say that is enough to bring every step that facilitates the sale within the statutory defence. Now, as we explained yesterday, we say that's wrong, and one needs to consider whether the terms of the actual transaction are within the statutory defence. And again, then it comes back to the same points I made a moment ago, that it's never been suggested that the purchaser required the dividend to be declared for the sale to go through, and also under the terms of the agreement there is no condition precedent for the removal of the receivables for the sale to complete. So even if the transaction is the wider arrangement, the judge still should have asked herself, and didn't, whether it was within the statutory defence to have a wider transaction which required the removal of the cash by way of dividend from the company before completion, and why that step, why a transaction with that step was reasonably believed to benefit the company. And the court, we respectfully suggest, as we showed yesterday, never grappled with that. Instead, the judge looked at it from the perspective of Rockrose rather than the perspective of the company itself. So we do say that whether we are right or not on ground 1, which of course we say we are, we say we still can succeed on ground 2. The other point, which I thought I would have to do more on, but we didn't have many paragraphs referred to by Mr. Nash, was factual findings within the judgment, in view of some comments by my Lord the Master of Rolls yesterday. Now, I hope I've addressed that sufficiently yesterday in explaining why the right question wasn't asked when reaching those findings, and why the wrong legal test was applied when reaching those findings. And for that reason we say, I think there are 3 categories of findings in broad terms that we say we don't need to get round to succeed. Category 1 is the findings that a sale in general of the company would benefit it, and that belief was reasonable. Now we say that falls down because one needs to consider the particular terms of the sale. One can't just posit a sale in the most general way and tick the box. Category 2 consists of findings that the dividend was implemented as an afterthought to achieve a cash and debt-free sale. Now, I fully recognise if we were appealing the 423 decision on purpose, that finding would be a real problem. But in the context of undervalue, we say it's not. In fact, we say it's an assistance to us because it demonstrates, 1, that the dividend really was a separate transaction entered into on its own at the end of the piece, and that number 2, it wasn't an essential element of the transaction, even if one takes the broader view of transaction. And category 3 are the findings that the defendants reasonably believe that FOI GC would stand behind the company. Now, the answer really is to repeat the point I've just made, which is it doesn't follow from that belief that a sale on terms agreed, namely a cash and debt-free sale involving an 84 million dividend, was reasonably in the interests of the company and therefore benefits from the statutory defence. And in order to answer that question, the court again would need to ask why the dividend from the company's perspective formed an element of the transaction. And we say, repeating of course, that the judge doesn't ask that question. So they are our submissions on grounds 1 and 2, I hope, leaving sufficient time to deal with ground 3, subject to the court.
Thank you very much. Thank you. Yes.
I'm grateful, my lord. A few short points in reply on ground 3A, as it were. My learned friend suggested in the course of his submissions this afternoon that the Bruin Dolphin case is fatal to my argument, as he put it. And I understood him to make 2 points about that case. His first point was there was no term in the share sale agreement providing that the lease money from the parent would constitute consideration, and yet it was taken into account. But as my Lady Justice Falk pointed out, draft transcript page 104, lines 2 to 7, there is a reference in the House of Lords judgment to a memorandum setting out the commercial deal, which envisaged that the lease money would constitute consideration for the sale of the business. When that was put to my learned friend, his answer to it was that the memorandum was a one-sided document, as I think he put it. In other words, it's unilateral and not bilateral. But that, with respect, is not a good point, because Lord Scott said expressly that the memorandum was evidence of what had been agreed, in other words, bilaterally rather than unilaterally. And perhaps I can quickly show the court that. It's Authorities, Volume 1, Tab 4, page 52. It's just above letter C, just before the quotation. Lord Scott says the memorandum described what had been agreed, in other words, agreed between the parties. So it's not an account of some subjective or unilateral intention, but evidence of what had been agreed. So it's not inconsistent with our case. Second, my learned friend relied on Lord Scott's more general observation that the question of consideration is a question of fact. Now, for one thing, as my Lord Justice Newey pointed out, Lord Scott goes on immediately to say, after making that observation, that consideration must be for the transaction. So then the question is, what type of nexus is envisaged by the description for, and in particular, is a but-for relationship sufficient? When that question was put to my learned friend, his answer was that a but-for relationship would be sufficient. But that, with respect, is not right. For one thing, as my Lord, the Master of the Rolls, pointed out, if but-for were enough, it could have the consequence that two entirely distinct transactions are both taken into account under 238 merely because the but-for test is satisfied. And indeed, in the example that I gave in opening, where an insolvent company writes off a debt owed to it by a related party, who then sends the company a bottle of wine at Christmas, it may well be the case that the bottle of wine would not have been sent but for the write-off of the debt. Indeed, that probably would be the case. But it could not, in any normal sense of the word for, be suggested that the wine was consideration for the write-off of the debt. That would be the consequence of accepting my learned friend's submission that but-for is sufficient. I'm not saying but-for is irrelevant. I'm just saying it's not sufficient. And my learned friend needs it to be sufficient for the argument even to get off the ground on the facts of this case. The other point I would make about Lord Scott's description of consideration as being a question of fact is all that means is that there's no gloss or legal rule as to what is capable of constituting consideration. For instance, my lords, my lady, in the law of contract, we have certain rules about things that cannot constitute consideration. For instance, past consideration traditionally cannot constitute consideration, subject to some exceptions. That may not carry through to the statute. But it doesn't mean that consideration need not be given for the transaction, which is my fallback case, or that it need not be provided pursuant to a term in the transaction, which is my primary case. So that is what we say about Bruin Dolphin. If I can turn next to Sequana, again, I think my learned friend made two separate points about Sequana. His first point was that paragraph 50 of the judgment of Lord Justice David Richards, as he then was, on which we rely, my learned friend submitted that that paragraph does not, quote unquote, lay down a rule of general application, as I think how he put it. There are, with respect, two problems with that submission. First, if para 50 is not laying down some principle, a rule of general application, it's not clear to us on my learned friend's case what it is doing. Because plainly, para 50 is not simply saying something about the facts of that particular case. It's couched in more general terms. It refers to a hypothetical example about an investment in a with-profits fund. So it is, on any view, articulating a principle, and the question must be what that principle is. That's what the debate is about. Second, if one just stands back and asks, a point I think my learned friend didn't really address, which is, why is it, on the facts of Sequana, that the dividend was found not to be a gift before we even get to the transaction analysis? Now, I remember, as it happens, I was in the Sequana case, so I remember in the course of argument, Lord Justice Henderson made a telling observation. He said, when ICI declares a dividend to its shareholders, you do not read on the back pages of newspapers about ICI making a load of gifts, do you? And what that observation, which carries through to the judgment in Sequana, it reflects the intuition that when a company pays a lawful dividend, it's doing that in return for something it previously received, namely the shareholder's original investment. And that's why you don't read that on the back pages of the newspapers. Now, that thing which the company had previously received was sufficient to negative the gift argument which BAT was running. But it did not count as consideration for the purposes of the second limb of Section 423, that is to say, the transaction for no consideration. And in our respectful submission, one does have to stand back and ask, why is that? Why is it that the same thing can negative the gift analysis, but not the transaction analysis? One possible answer to that question is the timing point that my Lord Justice Newey put to me, which I'm going to come back to, although I did not understand my learned friend to adopt the timing point. But parking the timing point for now, the only conceivable explanation in our submission of the result in Sequana, namely a dividend is not a gift but is a transaction for no consideration, is that the thing that's alleged to be the benefit must be provided pursuant to the terms of the transaction, and the dividend did not contain any. So that's what we say about my learned friend's first point, which concerns paragraph 50 of Sequana. My learned friend made a second point. This is, I think the references may change, but it's page 95 of the draft transcript, lines 15 to 25. He relied on the difference in language between A and B, and my lady pointed out that those are expressed as alternatives. Now, it's right that there is a difference in language. We can go back to it if we need to, but I mean, the court's familiar with it. Essentially, the words on terms that provide for appear in A but not in B. So Parliament has expressly used that phrase. Perhaps we should just have that in front of us. It's page 996, volume 3 of the Authorities. So A does say expressly on terms that provide for, and B doesn't. B says company enters into a transaction with that person for a consideration, the value of which, etc. But in our submission, it doesn't follow from that the terms requirement applies only to A. Indeed, that would be slightly surprising, because if the terms requirement exists at all, it exists for a purpose, and Parliament is unlikely to have intended that there must be a term in a no consideration case, but there doesn't need to be a term in a partial consideration case. The better reading of the provision, and I'll go to an authority in a moment in our submission, is that the draftsman, having introduced the concept of consideration in A by using the words on terms that provide for, is thereafter using shorthand in B when the draftsman refers to consideration, and shorthand for the concept that's more fully expressed in A. So our primary case is that whether you're in A or in B, something counts as consideration for the purposes of the statute, only if there's a term, which, as I submitted in opening, doesn't need to be expressed, that provides for it to be received. Now, there is one authority that insists on this, although I have to accept the point didn't actually arise for decision, and I ought to make that clear. It's the Invest Bank case in the Supreme Court, Volume 3, tab 25. Page 786. Picking it up in the second sentence of paragraph 1, if the court has that, in the judgment of Lady Rose and Lord Richards.
Sorry, which paragraph?
It's paragraph 1 at page 786, behind tab 25. So, in the second sentence, the court said this: in very broad terms, section 423 provides remedies to creditors in circumstances where a debtor takes steps to defeat or prejudice their claims by entering into a transaction, which is very broadly defined, on terms that provide for the debtor to receive no consideration or consideration worth less than the consideration which the debtor provides. As I read that sentence, Lady Rose and Lord Richards take the terms requirement to qualify both subsections. That's why the sentence is drafted in the way that it is.
Well, they say in very broad terms.
Yeah.
And that's a sort of equivalent of
Construing it as a deed.
I would not dissent from that, my lord. As I said it before I even took the court to it, the point didn't arise for decision. I think the most I can get out of it, if anything, is this: that commended itself to Lady Rose and Lord Richards as the natural reading of the provision. That's all I seek to take from it, and that's what we say is the right reading of the provision. So that's what we say about my learned friend's submissions on Sequana. On the timing point, just to give the court a reference, that was raised by my Lord Justice Newey at day 1, page 114, lines 6 to 13. So the timing point was that an alternative explanation of what I've suggested is otherwise an inconsistency in Sequana is that the consideration was received in the past when the shareholder bought the share and the dividend is paid later. That's why it's not taken into account for the transaction limit. Now, the court has the submissions I made an opening about the timing point, which I won't repeat. But in addition to those submissions, one difficulty with the timing point is that I'm not sure why the point, whether it's a good point or a bad point, would have any greater force in relation to the gift limb than it would in relation to the transaction limb. One would expect the timing point to work the same way in relation to both limbs. Because just standing back, if one asks oneself, what is a gift? Not a question the court normally has to grapple with, but a gift is something that I get for free in formal terms. I haven't given something in return for it or promised something in return for it. What we know from Sequana is that past consideration can prevent something which would otherwise constitute a gift from constituting a gift, because that's what happened there. But if past consideration is capable of doing that in relation to a gift, it ought in principle equally to be able to prevent something which would otherwise be a transaction for no consideration from being one. Yet, despite that, the Court of Appeal found in Sequana that the dividend was not a gift, but nonetheless a transaction on terms that provided for the company to receive no consideration. And we rely on that as a further reason in support of our primary case as to what the word terms means, and the court has my submission about the rationale, which I won't repeat. I'm nearly finished. That's all I wanted to say about the law. Turning to what the learned judge found, my learned friend made a point about para 250 of the judgment, full bundle, tab 7, page 193. I think my learned friend's submission was that the first sentence of 250, where the learned judge says, I accept the entirety of the premium to be chargeable to UKCS 8, he suggested that that is a finding that stands independent of what the transaction is. Now, there are two reasons why we say that's not right. The first was put to my learned friend by my Lady Justice Falk, which is that if you look at the last sentence of 234, that's at page 188, the premise of this part of the learned judge's analysis is that the relevant transaction is a wider arrangement. So that's the final sentence of para 234, where the learned judge distinguishes sequana. So that must inform the construction of 250. But there's also another inconsistency, which is at page 186, paragraph 230. In the final sentence of 230, the learned judge records my learned friend's submission about what the transaction is, and the submission was this. In the present case, he said, UKCS 8 participated in the wider arrangement by performing one of the linked steps, namely by declaring the dividend, for which it received consideration in the form of the pension liability write-off, also as part of the wider arrangement. And that is then the submission. The learned judge accepts at 231, which feeds into the factual finding at 250. So it's all parasitic, we would submit, on the learned judge's analysis of what the transaction is. The last point I wanted to make concerns the application of what we submit the law is to the facts. If our primary case succeeds, namely that a benefit counts only if there's a term, then we submit it's clear that the pension write-off is just irrelevant as a matter of law, irrespective of whether ground 1 succeeds. But even if our primary case is wrong and our fallback case is right, in other words, the benefit has to be for the transaction, a quid pro quo, it wasn't. And I would respectfully suggest that when this was put to my learned friend by my Lord Justice Newey, there wasn't a satisfactory response other than to say a but-for test is sufficient. It's not. And it's not realistic to suggest that the dividend was paid in return for, or to put it the other way around, it's not realistic to suggest that the pension liability was discharged in return for the declaration of the dividend. Indeed, my learned friend's case, both below and now in relation to ground 2, is not that the pension debt was written off because the dividend was paid. It is that the pension debt was written off because all debts needed to be written off to achieve a cash and debt-free sale. Indeed, para 230 final sentence, which we just looked at, recording my learned friend's submission, was making that point. So we do say that irrespective of the outcome of ground 1, ground 3 should succeed. And subject to the court, those were my submissions in reply.
Thank you. I'm not encouraging this, but I think you have a right to reply, Mr. Hubbard, probably, on Investbank.
There's nothing to say on Investbank that didn't fall from the bench.
Thank you, Mr. Hubbard. So with that, we will take time to consider our judgments and hand them down in the usual way in due course. When we do that, can it be absolutely clear that nobody must use those judgments for any other purpose than making typographical corrections to the court and agreeing an order as to costs and agreeing the order, and it's likely that we will allow only a little time for that to be done, and we'll give you notice of when it's going to need to happen, but we may give you a little more time to agree the costs and the order, because that in this case particularly might be rather complicated, and in those situations you probably need a bit more time. But it is very important that in the period between hand down or between release of the draft and hand down, the judgment is not used for any purpose whatever. But with that, it only remains for me to thank all of you, leading and junior counsel. It's nice to see all counsel participating in the oral argument. We find that valuable, helpful, and it's really the right way for it to be done. So I'm very grateful, and thank you to the solicitors and obviously to everybody else. So we'll consider the interesting points very carefully.